everybody. We're back with another video to explore a couple more of the states. And today we're going to talk to Damian Davenport in Utah. And Damian's one of my favorite attorneys, absolutely. And my next door neighbor to Nevada, of course. But Damian, why don't you introduce yourself real quick?
Absolutely. So my name is Damian, as Kim mentioned. I have a law practice here in Salt Lake City, Utah. I started my own law practice in 2003, began practicing in the area of assisted reproduction in 2005, which just so happened to coincide with the same time that the Utah legislature passed our gestational agreement statute. Since that time, I've developed and built my practice exclusively in the area of assisted reproduction. From a family perspective, I have a lovely wife that I've been married to for 24 years, almost 25. We have one soon-to-be 16-year-old son next week. So we're getting excited for that chapter in our lives.
My son's 14, so he'll turn 15 in November. So is driving age 16 in Utah also?
It is, and we're super excited that he's.
Are you excited? Good. I'm scared. Good. All right. Well, and you've had your practice. I guess we could do the math really quick because that's 20 years. So, and you've been doing reproductive law as long as I have. So, tell us a little bit about reproductive law in Utah. I mean, just generally, big picture, how does Utah, operate in that area of law?
Sure. So in 2005, our legislature passed our gestational agreement statute, authorizing gestational surrogacy agreements. It's part of our Uniform Parentage Act here. And it's been an interesting 18 years, hard to believe. I started practicing in this area due to my wife she and I struggling with our own infertility for about 5 years, and found out that there were no other attorneys that were practicing in this area of the law that long ago because it was relatively new. So it's been a very fulfilling position for me to develop my practice in this area of the law and to work with couples who have been struggling like we were to build their family through assisted reproduction.
I assume, I talked to a lot of attorneys that have ventured into this area of law because of their experience. I did not have any fertility background experience. I just had friends that were struggling to have families, but I assume, that gives you a different insight and a better ability to communicate with your clients, I assume.
It does. I'm fairly open with regard to our 5-year struggle, and I think I can relate for the most part with the majority of my clients. Now, obviously, each case is uniquely different, but it's allowed me to share that empathy that they're going through, and it's been a journey and continues to be a journey, and I'm very grateful that I have found something in the practice of law in my profession that allows me to wake up smiling every day, to come into the office every day, and to work with couples trying to build a family.
It's the best secret in the practice of law. I always tell people there's no other way to be a lawyer that is as good as this. There just isn't. It's impossible for somebody to argue to me. I get you don't necessarily litigate in other areas, and so that makes it better for some people, but you're not going to catch me saying tax law is better than reproductive law.
Right. Prior to developing my practice in this area, I was working in real estate and construction law. And there's no comparison. So in regards to the rewards that I have.
I did a small stint in insurance defense, and I sure as heck won't go back to that ever. But it was very short-lived stint. So, all right. So let's talk. People are going to be watching this video, wanting to know more about Utah. Towards the end of the video, we'll tell everybody how to get a hold of you because absolutely you are the go-to attorney for Utah. But let's start with donor agreements because that's a service that you provide and people can come to you. So, explain to people a little bit about how that process works with you and with Utah.
Absolutely. So that's the easiest part of my practice, to be honest with you. Our assisted reproduction statute is very straightforward. If you are a donor, you are not a parent. So it makes things very, very simple or simplified when it comes to drafting these agreements, whether they be sperm, egg, or embryo donation agreements, and then allowing the parties obviously to have those, whether it be sperm or egg or embryo donated, and to allow the recipient parents to receive those and to become parents of any of those offspring that are born through that process. So no court involvement at all. We have a presumption of parentage here in the state of Utah that the majority of my clients will rely upon, obviously with the donation agreement itself.
And with the donation agreements, I haven't covered this in my other videos, but of course, people are going to say, well, can't I just download a donor agreement off of the internet versus call Damian and have him assist me? Your advice on that?
My advice is always going to be to reach out to an experienced attorney that practices in this area of the law. There's going to be certain nuances that you'll want to discuss with your attorney specific to your unique circumstances. We oftentimes will see these donor agreements that are found on the internet that are very generic. And don't address the very specific situation that the parties may be dealing with when it comes to future contact with their that resulting child, with the recipient, or I'm sorry, the donating couple, the sharing of information, personal identities, things of that nature. And each person that comes to see me has different feelings towards that. And we always want to make sure that when we are drafting those agreements, that we're drafting them specifically to what their wants and what their desires are, obviously in accordance with Utah law.
Perfect. All right. So let's move on from donation agreements, because they are pretty basic for the public. There's definitely, as Damian stated, there's things that we need to negotiate and there are things to be contemplated. But the law is great in most places for us on that front. But let's move on to surrogacy, because of course that is a different beast. And let's just start from the beginning of the process so that people know if they're in Utah, meaning their gestational carrier is in Utah or their surrogates in Utah, interchangeable terms. But let's talk about that first, though. Can you have a traditional surrogate in Utah? Can she be genetically related?
Right. So our surrogacy statute, our gestational agreement statute, is gestational only, meaning that there's going to not have that genetic connection with the surrogate, or she can't donate, I should say, her egg. So our statute's not designed to deal with a more traditional or a traditional surrogacy. That takes us out of the statute itself when it comes to surrogacy, and would prompt the parties to have to go through probably an adoption of that child to terminate the surrogates, the traditional surrogates, parental rights post-delivery.
And for those listening, I mean, honestly, that's pretty standard across the United States. We have a few localities where we can start working with traditional surrogates under statutory schemes, but very few. So if that's what you're seeking and looking for, you really need to pay attention to the different states and really do your research, because adoption's not necessarily what's on the front of mind for most people. It's not what they're wanting to do.
Right. And again, I think that that's one of the important aspects of making sure that you're in contact very early on with an attorney that practices in this area of the law, so that you can understand those nuances that are there in that particular state, or at least here in the state of Utah with my clients.
Okay, so we took care of that part of it. What are the contractual duties, or what are the requirements in Utah for a surrogacy contract?
Sure. Like I said, in 2005, our statute was passed. Our gestational agreement was passed by our legislature. I like to tell all my clients to think about our framework, our process, as a three-part legal process. You have the contract formation, the drafting, the negotiation of the contract between the intended parents and their gestational carrier, and if she's married, her spouse. And then from there, we have to seek or file a petition with the court to seek the court's validation of that contract. Oftentimes, we're going to hear the terms pre-birth order. That's our pre-birth order here in the state of Utah. It serves two purposes. One, it makes that contract that you've signed with your surrogate enforceable under Utah law. And two, declares the intended parents to be the parents of that future child to be delivered by their surrogate. And then the third and final part of this process comes post-delivery. And we have actually a post-birth or a order confirming parentage that will be issued by the court once the delivery occurs. And as you navigate and you look at our surrogacy statutes, we have certain requirements that the parties are required to meet at each phase. So for instance, with the contract phase, most contracts, and this is pretty, I think, consistent across the US, will allow the parties to freely negotiate the terms of that contract. But our statute does require certain things to be included in the contract itself. And our statute also prohibits certain things from being included in that contract as well. In particular, and this is very consistent, I think, with what we see across the US, is we always want to make sure that the financial arrangements or the reimbursable expenses for the pregnancy costs are going to be addressed. Who's responsible for those fees, those expenses? And statutorily speaking, that is something that we do have to provide for in all of our surrogacy contracts here in the state of Utah. And we also have to even address that in the event the contract is terminated by the parties. One of the things that we're prohibited from doing here in the state is taking away the surrogate's right to safeguard her health or the health of the child that she's carrying. So that's going to dramatically impact multiple issues when it comes to healthcare for the surrogate as well. From there, we really allow the parties to truly negotiate. We are a compensation state, meaning that our surrogates are allowed to be compensated. There is a requirement that the court at the pre-birth order stage find that the financial consideration is reasonable. So we do have to include the terms of the financial terms in the contract itself. But again, from that point, we do leave it up to the parties to discuss and to negotiate any other terms of pretty much which we see across the country in regards to prohibitions, not participating in dangerous activities and travel restrictions and following medical advice. Those are the types of terms that we'll typically include in a gestational agreement.
So on the medical decisions for the carrier, just give some examples, because I'm sure, I mean, it is a little different statute for Utah than we see in some of the other states. As an example, if the intended parents really wanted to insist on a C-section versus vaginal delivery, can they do that in the contract?
I think it's something that the parties can maybe negotiate in terms of including those specific provisions in their contract. But I think the difficulty comes in the enforcement of those provisions. Okay. If you end up in a contract dispute, I would think that there's going, and we haven't had any case law that has developed in this particular, with regard to this particular issue. But I would assume that courts are going to really scrutinize those statute or those contractual provisions and look at them as to whether or not they would be opposite to a woman's decision, the surrogate's decision to safeguard her health and
safeguard her health.
Right.
Yes, that's why I was trying to differentiate between the safeguard her health. I mean, if she's bleeding out, that's probably crystal clear under your statute, versus whether she takes pain meds or not, right? Or
right.
Okay.
And even further along those lines, and some of the harder issues that I think we address as attorneys and have negotiations with the parties has to do with abortion and selective reduction and just those really truly necessary healthcare decisions that have to be made for any woman who's carrying a child. So we have to be very cautious about our approach. And the best advice I can give my clients is when you come see me or when we're working on drafting those provisions, making sure that we're very open and honest, that the intended parents are open and honest with their surrogate, and making sure that she's open and honest with them in regards to how the parties feel about those very specific particular issues.
Yeah, we're for those watching, we're trending away from the contracts that have the excruciating detail about controlling her medical decisions as a country. I mean, the Uniform Parentage Act, the 2017 version, puts all of those decisions in the carrier's hands and not in the intended parent's hands. Now that body autonomy over your own medical decisions perspective. Okay. So you can negotiate everything else with the contract. Are there, notarization rules? What do we need to know about finalizing the contract with Utah?
And so in Utah, we don't have any requirement for notaries. If the pandemic has taught us one thing, it has allowed us as attorneys to develop our practice in the area, in this virtual world that we now live in. So a lot of the contracts, unless it's a necessity with a clinic or other state law, if we're working with other state laws as well, we typically, or at least I typically, will have the parties electronically sign their contracts. And then we are required by statute to then file a copy of that contract with the court at that pre-birth order stage.
Okay, but the court's okay with the electronic signature versus
Absolutely.
Wet signature is what we differentiate. Okay.
Yes, absolutely.
All right. Well, that makes it easy. That makes it easier, at least for some of the international intended parents, especially, right?
For sure.
Yeah.
And I think, again, with the way that the pandemic has taught us to become more virtual and electronic, at least in so many things that we weren't before, it allows the parties to work directly with their counsel virtually in a virtual format and to carry that forward in regards to the written documentation that we need.
Great. All right. So contract's done. We're moving forward. The filing of the contract with the court. What's the timing on that?
So that one's an interesting question. Again, as we develop and delve into this part 2 of this 3-part legal process here in Utah, and we're focusing on asking the court, as I mentioned, to validate the contract, to make it binding, to make it enforceable, and to declare the intended parents to be the parents of that child. And it's that validation process that can be somewhat unique. I know there's other states that have a similar language or have similar things. But the validation, our statute itself says until the court actually validates your surrogacy agreement, it's not enforceable under Utah law. So going back to the timing, it becomes very critical. It doesn't say it has to be done. The statute doesn't say it has to be done before the embryo transfer, but it is very specific, and it does state it's not enforceable until the court's validation. So the parties have to decide when the appropriate timing to seek the court's validation. And in my opinion, to give the parties the full breadth of protection under Utah law to make that contract enforceable, make it valid, we would strongly encourage the parties to do that prior to the embryo transfer itself. Now, obviously,
later, right?
Absolutely. And for those of my clients who choose to wait, typically, at least from my perspective, I don't want them waiting beyond 18 weeks. They can start at any time before that. Some start after that. But the process takes, at least in my practice, the process can take approximately about 4 to 6 weeks to gather everything that we need to gather, to prepare the court paperwork, to submit it to the court, and then to obtain that pre-birth order. So if we're starting that around that 18-week mark, then the expectation is at around the time of viability, at around 24, 25 weeks, we are going to have that court order in place where, if we did end up with a complication that gives rise to a premature delivery, we've got an order in place that actually secures those parental rights to the intended parents to allow them to make those medical decisions.
I assume you get pushback from parents and agencies on doing it too soon because they're afraid of spending the money before they know if they're pregnant.
Absolutely.
Yeah. Is that the pushback? Okay.
Yeah, the risk is obviously spending the additional attorney's fees to validate a contract, but there being no guarantee that their surrogate is going to become pregnant. And it's already a very expensive process. So adding additional attorney's fees to the process is something some intended parents are willing to do to eliminate some of that risk, and some of them are not. Some of them are more willing to wait until after there's been a confirmation of pregnancy, to wait until they get further into the pregnancy to avoid some of the concerns of miscarriage or a loss of that pregnancy. For those clients who choose to do so, I tend to find that sometimes, and here's a good example, if they have a very close family friend or a close family member who is going to carry their child for them as a surrogate. There's a lot of trust and a lot of faith that is in that relationship before they even come to me and decide to draft a contract. So oftentimes this risk, this idea of their contract not being enforceable in their eyes is not a great concern. Some other examples would be if a couple only has a single embryo left. And after that single embryo transfer occurs, if it fails, they're not going to pursue assisted reproduction anymore, and in particular gestational surrogacy. So they're weighing the risk of spending those additional attorney's fees with the possibility of that embryo transfer failure.
Is there certain rules around which court they can file in or not file in?
No, so we actually don't have a specific venue statute for our surrogacy law. And I tend to, as I mentioned, my practice is here in Salt Lake. And I tend to file all of my
The closest
contracts. Yeah, just
Yeah.
here. We are the biggest, probably the biggest district court in the state. So numerous judges are very familiar with this area of the law. As you get further and further out of the Salt Lake area and surrounding areas, it becomes more rural. So you don't see the judges handling those types of cases all too often. So creature comfort, right? We want it to stay where we know, and we've been very successful, and we haven't had any significant issues when it comes to the pre-birth order or the obtaining the pre-birth order for intended parents.
The court filing fees, are they by petition or are they per party?
So they're by petition. We file.
So you're more like Nevada. Yay.
Yes. And in the grand scheme of things, it's not a ton of money, but it's currently $375. It's been many years since that's gone up, but when it did go up, it went from $360 to $375. So not a huge jump when it comes to filing the filing fee to the court.
No, that's good. That's very much like Nevada. In California, we're looking at per party, and it becomes significant at that point. So especially if you have a married gestational carrier and married intended parents, and you got 4 filing fees. So, all right, great. And actually, speaking of that, on the married front, what are the marriage rules in a surrogacy contract?
So in order for the court here in Utah to validate the parties' agreement to enter that pre-birth order, the parties do have to be able to demonstrate that they meet very specific statutory requirements. So for intended parents, they have to be 21 years of age or older. They have to be married. So we do not currently allow for single parents to utilize surrogacy here in the state, at least go through our surrogacy statute, I should say, for establishing a parental rights. There are other requirements. There's a counseling requirement for all parties involved, where they have to meet with a licensed mental health professional to discuss the options and consequences of surrogacy.
And they should anyways, whether
they
it's
should,
required
absolutely.
or not.
Absolutely. Yeah. I have not met a single person who doesn't advocate that we should all have, any party that is a part of this process should be meeting with mental health professionals.
Right. Okay. So what about the surrogate? Can she be single, or does she have to be married?
She does not have to be married, so she can be single. She has to be 21 years of age or older. She cannot be receiving Medicaid or any form of state assistance. We want her, and it's important statutorily that she have at least one healthy pregnancy and delivery. There's obviously going to be that medical clearance by the clinic doing the embryo transfer that will pass her medically to be able to carry another child. Counseling for her is important as well. Now, I should note that if she is married, her spouse does have to join both in the contract and in the petition. And the spouse also has to undergo counseling. So that's one of the things that I see working with agencies outside of the state of Utah are not familiar with our process, where only the surrogate has gone through that psychosocial evaluation and counseling and not their spouse. And oftentimes, by the time I start the parentage process, we need to get them back in. We need to get that spouse back in there to meet with the counselor.
Which could delay things significantly.
Absolutely.
So, I mean, that's a good pitch right there for know your state ahead of time before you start the whole process. Know exactly what you need to do and not do. So you're ready to go. And
Right.
Damian's not having to chase you around to get things done. So, okay. So when the court's looking at validating the contract, it's just the statutory requirements that they're looking at. Are they looking at anything else when they're
They
just?
are only looking at the statutory requirements, but I did save the worst for last. And not to scare anybody out there by any means, but one of the requirements for the intended parents is they do have to demonstrate to the court that they meet the same standards of fitness applicable to adoptive parents. Now,
Okay.
oftentimes a lot of my clients will ask, well, how do we do that? And what our surrogacy statute has done is it's incorporated the adoption home study statute into it. Thankfully, in my opinion, our legislature allowed, or when they created our gestational agreement statute, has allowed the courts to waive that requirement as well. So you have intended parents who can basically choose two pathways. One, they can go have an adoption home study completed, very similar to what would be completed if they were seeking to adopt a child, where a written report gets generated and an evaluation is completed, a written report is generated, and then that report is submitted to the court, essentially confirming to the judge that this couple, that these parents have the financial, the physical, the emotional well-being to be able to raise a child in their home. And in my practice, when we seek to waive the home study requirement, at least in connection with surrogacy, we're still providing the court with the same information. We're doing it a different way. We're not hiring a licensed clinical social worker, an adoption agency to come and do that evaluation of the intended parents, but we're still going to have the intended parents provide similar information that we can present to the judge when we ask the court to waive. And we've been pretty successful over the past 17 plus years in having our judges waive that statutory requirement. So again, I never want to scare the intended parents that when they hear that it is going to create issues. It's a rarity where the court doesn't waive the home study requirement, or sometimes I have clients, and I'm sure everybody else has clients out there that practice in this area of the law, where they're still considering adoption as an option to build their family.
They have it ready to go.
Absolutely, and they have it ready to go, and we can utilize that adoption home study in connection with their surrogacy as well.
I'd imagine the problem comes in with international parents. If the court doesn't waive, the concept of a home study in other countries isn't always the same.
It is, and that's very difficult. And again, I'm always advocating that when we're working with international clients, that that not only do they work with us here locally, but they've got an attorney in their home country that can help guide them through some of these issues. The majority of those countries that I practice in, or that I provide these legal services to with surrogacies here in Utah, don't have the equivalent of an adoption home study that's available to them. So unless they've done an international U.S. adoption where they've had one completed, there's no means available to them to provide that. And again, we've been very, very fortunate that our judges take a look at that and they're willing to grant those motions to waive those home studies. I've been very fortunate, again, in just my time that I've been practicing in this area of the law and providing these legal services in connection with helping international clients, that I've never had a judge not waive a home study. So they've always been very, very receptive to waiving that requirement.
Well, I would venture to say that's because you're comprehensive when you give the information to the court, and it's more about you as a lawyer than anything. But
well, and I think consistency plays a big role in
yeah.
that as well. And I've just developed a process in regards to getting that information to the judge, presenting it in a way that the judge can actually look at the information and decide whether or not this couple meets those same standards that adoptive parents meet. And if we're doing that day in and day out, and the same cases, now obviously the circumstances, the facts of each intended parent are going to change, but the information that's provided is consistent. And I do think the judges prefer that.
Right. So with in terms of contractual obligations, is there any restrictions on, I guess I'm going to give an example. California requires on medical insurance that it be reviewed and that you state in the contract that it's been reviewed. Anything with health insurance requirements for you?
There isn't. Right now, as I mentioned, there's a requirement that we address who's responsible for those pregnancy-related medical expenses within the contract itself, but we have no statutory provisions that deal with insurance. We have policies that are written, insurance policies, employer-based policies that provide coverage for pregnant women who are acting as a surrogate. But we also have policies that have been issued under the ACA where they have specific exclusions or
Okay, so you're not
potentially
one of
lien
those states that
language.
has struggled and struggled with insurance. You tend to have options.
Right. And we've been fortunate since the ACA has been around, the Affordable Care Act has been around. We've always had a policy or two that has been able to provide that level of coverage to a woman acting as a surrogate. Now, some of them fall out and some of them fall in and will create those exclusions. But we have been very, very fortunate that there's been a policy or two here locally.
Wonderful. So then what about escrow? Can you hold escrow? Are you willing to hold escrow? In Nevada, we've got a rule that makes it where lawyers should not. Our escrow rules are so intense that it's impossible for us to do it. But
My take on, so we don't have any specific statutory language that talks
okay.
about escrow. Obviously, I'm a big proponent of making sure that there is third-party escrow out there. I do offer that service as counsel for the intended parents to set up through my trust account, my IOLTA trust account, to pay those, to compensate or to issue payments to the surrogate reimbursed. Not something that I routinely do. It is a service, but at the same time, I always want to make sure that the surrogate understands, and at least when she's speaking with counsel, her own counsel, that she understands, obviously as counsel for the intended parents, there's that dual role that can create and be issued, be at issue at some point. I've never had that arise, but when it comes to escrow providing those services, not something that I do regularly and routinely. It is a service I offer, but there are a lot of, as you know, a lot of third-party escrow companies out there that do a fantastic job when it comes to escrow.
Yeah. All right. So you've got the contract validated by the court. What's the next step?
So at that point, nothing else needs to be done until after the surrogate delivers, after the gestational carrier delivers their child. Now, obviously, we want our intended parents to not be stressed out on the legal side of things on the back end when they're dealing with a newborn and they're going to be at the hospital welcoming their child into their arms. So what I always have my clients do is let me know when their surrogate delivers their child for them. They can shoot me a text, they can shoot me an email, and really what I need to know from them is that she's delivered. So the date of the delivery. I oftentimes will ask for the time of delivery as well, confirm sex of their child. And what I'll do after I receive that information is I go back to court. We notify the judge that entered their pre-birth order that their surrogate has delivered their child on that specific date. And that begins the final stage, at least from a legal perspective here in the state of Utah, where we will ask the court to enter a post-birth order or an order confirming parentage. And that's going to be very quick. So generally speaking, from a statutory standpoint, all birth certificates have to be registered in the state of Utah within 10 days of delivery. So we're oftentimes notifying the court within a few days, and we're obtaining that post-birth order from the court confirming the intended parents as the parents of that specific child and requiring vital records. That's the key part of this, requiring or ordering our vital records and statistics to then issue the birth certificate naming them as parents. So ideally on the back end, as the intended parents are at the hospital with their child, they will complete the birth certificate worksheet at the hospital. And the hospital will collect that information and provide it to our vital records here. And then once the final post-birth order is entered by the court, we provide that to vital records. And usually within 24 hours after vital records has collected the birth certificate worksheet as well as the post-birth order, they're going to register that birth certificate. It's going to happen really, really quick. The intended parents at that point can go to a vital records office and actually pick it up if they want, or they can create an online account and have it delivered to them.
So both the pre-birth or enforcement of the contract, however you call your first stage and your third stage, are there hearing requirements? Does anybody have to show up in court physically?
So we've been fortunate. So the judges are willing to waive those. We always ask for a waiver. We have the parties petition under oath that they meet all of those statutory requirements, and we do request the court to waive any hearings. And the judges are pretty receptive to doing that as well. I don't routinely in my practice go to court unless the judge asks us to do so. And on a rare occasion, we may. but it's very rare.
Okay. Now you've got that same tight timeline, that 10 days. Nevada has that too. So, I mean, I always tell people, just please don't have your baby at 5 p.m. on Wednesday before Thanksgiving. Because I have no ability to go to the court till the next Monday. So,
Right.
right.
And
It's like the worst
oftentimes,
day they could possibly do it.
sure. And oftentimes we find the judges want to work with us as well. And they're, if you notify them as to the particulars of the case, then we're going to find that they're very helpful in regards to getting those orders issued when we need to. Thankfully, our vital records is equally helpful as well. So if we're running into and coming up on that 10 days, as long as we're communicating directly with vital records, explaining what is going on, what the delay might be, there doesn't tend to be any issues there.
Okay, so let's talk a little bit about international intended parents and their needs. Apostles, I assume, or apostees, some people, I don't know how to say that word still. Everybody says it different. Is that a service that you can assist them with?
It is. In fact, in my practice, I offer that as a service, or I always let my clients know that I can give them very specific directions on how to go about doing that, save a little bit of attorney's fees if they want, because it's a very simple process here. Once we obtain the birth certificate, once we obtain the court orders, the certified court orders, then it's a matter of scheduling a time with our lieutenant governor's office to go obtain those apostilles of those documents. And depending on how much they want to pay, we can expedite it where it can be same day for more money than a 5-day turnaround. So we leave it
your
up to the
lieutenant governor is what I just heard. Ours is our secretary of state. So is that just one office you can go to for them, or is there more than one in Utah?
It is. So our capital is obviously Salt Lake.
Yeah.
So at our Capitol building, a lieutenant governor's office is there, and you can mail things to them and they can do it, or you can, as I said, set up a time. Yes, exactly.
Yeah. And wait.
And a lot of times it just depends on how much time the intended parents are going to stay here in Utah. We don't have a passport agency or a passport.
That was going to be my next question.
Yeah.
Neither does Nevada. I don't know what's
Right.
going on with our two states, but yeah.
Right. So oftentimes they're going to, once their baby's born and collect those documents, they want to move. They want to get closer, maybe to LA or San Francisco, where they can then typically leave from that point. So we can obtain those apostilles, those documents, we can forward them on to them if they need to, provided they give us an address that they're staying at.
Okay. And for the LGBT community with surrogacy, they need to be married, right?
Yeah, so at this point, there's no difference between a same-sex couple and a heterosexual couple in regards to our surrogacy law. So when our statute was drafted in 2005, there was some language that was specific to the requirement that we demonstrate medically that the intended mother is unable to carry a child. So we had that medical necessity requirement. And I had a case in 2017 where we had a judge that refused to validate, to enter that pre-birth order for a same-sex couple of mine, relying upon the language of the statute where there was a requirement that we find the intended mother's unable to carry a child. We were successful in appealing that case before the Utah Supreme Court, and in 2019, our Supreme Court ruled in favor of my clients, granting same-sex couples the same rights that heterosexual couples have here. And since then, and even before then, most judges were pretty receptive to reading that in a very gender-neutral way.
But drum roll, everybody, that's why you want Damian. That's why he's going to be your lawyer in Utah. He will fight for you. So, all right. Any other big things? Did I miss anything with Utah that people need to know before they come to you, other than come to you early? Don't wait so long.
Yeah, no, it's a pretty, once you've been practicing in this area of the law, it's pretty straightforward. Obviously, having that knowledge base, that experience, working with not only attorneys for intended parents like myself, but also working with legal counsel that has on the other side, right? Where there's no requirement. I think it's important to note there's no requirement in Utah, and I've seen this with different state statutes, surrogacy statutes, where there is a requirement that the surrogate have her own independent legal counsel. We do not have that requirement in the state of Utah. Now, we all agree, I think, as attorneys
Best
in this area of the
practices.
law, that it's the best practices to have an attorney on both sides, making sure even if that surrogate is a close family member or a close family friend, making sure that she has the availability of competent legal counsel that she can discuss and review that contract with. And I'll go even farther to say that she has that representation, independent representation during the parentage proceedings as well.
Right. I agree. Absolutely. And I mean, we didn't mention this in your resume. You, like me, we're both fellows with the Academy of Adoption and Assisted Reproduction Attorneys. We both participate with different things with the American Bar Association. So there's Damian's got a resume, everybody. I'm just letting you know he is the attorney you should go to in Utah. And I appreciate your time today, Damian. Everybody else.
It's been fantastic. Kim, I love what you're doing here. I think getting the word out, allowing these videos to circulate so people can actually see what is unique. As we all know, surrogacy is very specific to the states. And making sure that we're focusing on the law of the state where the surrogate's going to deliver. That's going to give, in my opinion, the intended parents the best protections available to them.
Absolutely. And letting agencies know. I mean, we've got attorneys in every one of these states, and you really need to be focused on them and just being ahead of it, because there are intended parents that are looking at a lot of different surrogates, and they're looking at multiple states and trying to decide between them. And so hopefully we'll get the good information out. And
I am going to give a shameless plug at the same time, because I want to make sure that everybody knows too, and this goes on what you were just saying, and we have intended parents that are either working with agencies or doing finding their surrogates independently, and they've got different options with surrogates living in different states, and I think it's very critical that intended parents understand the state law where their surrogate's going to deliver, and that they utilize that understanding before they make that decision on whether that is the best fit for them. Different states, different rules. So making sure that the rules of the state where your surrogate's going to deliver actually fits what you're looking for. And as a result of that, I do offer a free consultation to all intended parents who want to sit down and understand what Utah law is when it comes to gestational surrogacy, so that they can decide for themselves if that particular surrogate they're choosing is the right fit for them.
And I'll take it another step, which is if you're intended parents and they've gotten your carrier a attorney in Utah, but they haven't gotten you one in Utah, we have multi-jurisdictional issues. We may have a fertility clinic in another state. Nevada is one of those. We have a broad jurisdictional rule, but I am a firm believer those intended parents need some Utah advice. Don't rely just on your attorney from the other state. And so, I mean, it's happening more and more. We've got attorneys trying to be kind of jack of all trades for multiple states, but unless their license is actually there, they don't have to be physically located in that state. But if they have a license in that state, you're in much better shape, and you need to hear directly from the horse's mouth. There goes Kim and her cowgirl responses. But can you also tell us, Damian, how people can get a hold of you, please?
Absolutely. So you can get a hold of me through email at Damian@davenportlaw.net. That's Damian, Damian @davenportlaw.net. Also, my telephone number is 801-531-6195.
Perfect. Wonderful. I appreciate you. All right, everybody. Until next time, we'll reach out to another state and join each other.
Thanks, Kim. Take care.